Well, I think what people realize is when you have a board, that board is in such a position of power.
Yeah.
And, often when a board is acting poorly or failing to perform, there's certain consequences, and typically those are economic.
Yeah.
But what I think people are waking up to is like, no, life and safety is at risk as well. Life and limb.
Yeah.
The board is charged with not only sort of an economic responsibility, right?
Yeah.
They want to preserve fair market value of the community.
Yeah.
But no, this goes so far to say that they're responsible for the safety of individuals. I mean, building codes, enforcement issues, CC&Rs, all of this exists for a reason. And of course it is to preserve fair market value, but it's also to preserve safety. I'm Luke Carlson, and for almost 2 decades, my law firm, LS Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of LS Carlson Law. Welcome back to the show. Today I have Marty back, our producer.
Good to be back, as usual.
Yeah, good to see you. And today's topic is negligence. So, Marty, in my mind, this is like the big topic for most homeowners, negligence.
Is this the big one?
I would say so because it touches upon so many areas of someone's life. When you have negligence or the board is acting negligently, it can just infest so many different areas of your life, and it is one of those topics that comes up time and time again.
Is this one that you would, in terms of the percentage of the pie, does this take a nice chunk of that pie of the things that you see? Yeah,
so the majority of what we see is, you see a lot of breach of fiduciary, you see breach of CC&Rs, but quite often when you see those causes of action, negligence is riding shotgun.
It's the through line.
Yes, it is.
Well, let's recap real quick. We're in the dispute series,
yep,
and we're getting down. On the second half of the dispute series. Okay. So, it's an exciting topic to cover.
Well, I think it's we're going to end it with a bang in a way because, like I said, negligence. Well, let's define negligence.
Yeah, let's do it.
Let's start there because I think a lot of people throw around that word and really don't understand what it means.
Sure.
And the implication of that. And what I want to do is really simplify it. Because, once you sort of understand what it is conceptually in a very simple way, I think it's better for the homeowner to be able to spot it, to label it and identify it correctly.
Yeah, I think that would be helpful for you as an attorney to define it, not just what people, these days everyone is bipolar. It gets thrown around just like as that person's crazy. But there's a clinical actual diagnosis.
There's a definition for it.
There's an actual definition, a medical definition, whereas we're looking for the legal definition perhaps, or to the best of your abilities, or in the context of which you see.
Yeah, and what I want to do is simplify it to an extent. Really, when we talk about negligence, we're talking about a standard of care. There's a certain standard of care that's expected. So when you look at a board, there is a certain level of care that they're supposed to take with relation to the community itself. And when their conduct falls below the standard of care, and that conduct has consequences, which is sort of real damage, it actually impacts you as the homeowner, it impacts your property, now we're in negligence land. So it's really falling below the standard of care, and that failure, right, to not hit the standard of care results in some sort of damage to you as the homeowner.
Sure.
That's what we're looking at here.
Now, is the causation, is it mostly, we're talking about like the person, going back to the personality types, is it the incompetent? Is that typically?
Okay, that's good. How are you going to? So previously we identified different personality types on the board.
Yeah.
You have the tyrant, the incompetent,
the meddler,
the embezzler. Or do we call it the embezzler? The embezzler type?
No, the self-dealer.
Self-dealer,
yeah,
embezzler. They're interchangeable. Really, when it comes to negligence, I think you're really looking at the incompetent often. The incompetent not realizing they owe the duty to the homeowners.
Yeah.
Right? Because you have to have a duty as well to establish negligence.
Yeah.
But, they owe this duty. They don't realize it, or they realize it, but they don't really know what the standard of care is because they never inquire. They never look into it.
Now, we've mentioned standard of care a couple times now. Is that well defined in CC&Rs? I have a suspicion that the answer is it depends.
well, let's back out a little bit because it depends. It depends on what you're looking at.
Okay.
And I think we're sort of jumping in a little bit to some of these concepts that you have outlined. But if you look at, for example, I'm just going to use an example of a common area roof.
Yeah.
Okay. In the CC&Rs, there typically is some sort of provision that says the association must repair and maintain the common area roof.
Mm-hmm.
The incompetent reads that, or doesn't even read it, doesn't realize it's in there, and just ignores it. Ignores the roof, ignores maintenance, doesn't do anything for a very long period of time.
Yeah.
Well, that arguably is well below the standard of care.
Okay.
They took no proactive steps to repair, maintain, inspect. Furthermore, the incompetent never reached out to a roofer and said, hey, what's the best way to keep this roof maintained?
Mm.
And if an expert was to come in, a roofer, and said to the incompetent, said, you know what, every year I recommend someone go up there and take a look.
Yeah.
Well, that would really set the standard of care. Or the incompetent could rely upon that expertise and say, well, we inspect it every year, and therefore, most likely the standard of care is going to be met.
Okay. But there isn't, to answer the question, standard of care is just, it's not a definition of standard of care. It's just that in the CC&Rs, it is listed what the
expectation is.
The expectation of the association is. Now, let me ask you this. You have a board, and you've got a board. Obviously, we've gone through this multiple times where these are elected people within your
elected and volunteered.
Elected,
yeah, they volunteer.
Elected and volunteered.
And
there's a good chance that they have no experience running any sort of business or any sort of venture whatsoever.
Right.
And so this is way outside their wheelhouse, yet they're now put in charge of this. To some degree, and I think, and I'm going off the rails a little bit here. We'll get back to the format. At what point does the property when you bring in like a property management or a community manager to oversee the whole operation? At what point do they say, hey, you need to have X, Y, and Z? How do these look? I mean, is there any sort of
I hear what you're saying, and that's actually a great point because the association is built of volunteers.
Yeah.
Right. And often they have no idea what they're doing.
Right.
So a well-functioning management company will slot in and say, when it comes to the common area roof, this is what needs to be done.
Yeah.
When it comes to the piping, this is what needs to be done. When it comes to maybe the bookkeeping or the financials, this is what needs to happen.
Yeah.
And the board can rely upon that expertise in making decisions.
Yeah.
Now, the issue comes in, and I'm sure we're going to get comments to this effect, well, my management company is a dumpster fire. They're horrible. They're the worst ever. Okay, and that might be the case.
Yeah.
But just because the management company is, let's say, negligent in their approach, it doesn't alleviate or doesn't let the board off the hook.
Sure, it's the buck stops with them regardless.
Correct, because not to get too complicated, but when you have a management company, it is the agent for the association.
Sure.
So any sort of misconduct, negligence of a management company is simply imputed back to the association.
So to the extent that if the management company is failing at their duty, it's the HOA, the board's responsibility to replace them with a competent
correct
company.
Yeah, and sometimes, this gets interesting. So if a management company is acting negligently and let's say wreaking havoc on a community, and the association or the board does nothing and allows it to happen, in addition to a breach of fiduciary cause of action, you might actually have negligence. The board was negligent in allowing for this management company to wreak havoc. So you have like a duality there of negligence or a multi-dimensional claim of negligence.
I think they call that a fractal.
Maybe.
Where you look into the looking glass and it continues on
yes,
forever.
Yeah, so you have one of those situations. So it gets interesting. But I guess to add on top of that too is where you have an association, and let's say the management company has really caused some harm to the community as a whole.
Yeah.
Not only would I argue that the association at that point needs to terminate, but they would contemplate whether or not it makes sense to take legal action against the management company. So let's say the management company caused millions of dollars to damage to the community.
Yeah.
And typically you're looking at the common areas, right?
Yeah.
Maybe they allowed the common areas to fall into a state of disrepair.
Sure.
Or the pool is now leaking, whatever the case might be. The association at minimum should at least contemplate whether or not to take legal action to be reimbursed, to be made whole again.
Sure.
But you get into situations where the association just doesn't care.
Yeah.
They allow the management company to do whatever they want, and it's often to the detriment of the community and the homeowners.
Well, I could see a management company bullying around a newly elected board. Like the board doesn't know anything. You know what I mean?
Yeah.
Like,
So that's that. I have seen that where the management company is really the captain of the ship, which it's not supposed to be that way.
yeah.
But because you have very soft leadership or no leadership whatsoever in the association,
Yeah.
the management is just doing what they want to do, and they're benefiting, right? Because they're getting paid to do it.
And they're saying, well, this is how it normally goes. I mean, you don't know anything about, you've never run this thing, so they can easily manipulate their way into thinking that they don't know any better.
I would put a caveat on the word easy, because if you look at an ideal situation for an association, association has corporate counsel, association counsel. And hopefully that corporate counsel is also keeping an eye on the situation, right? Hopefully. Now, that doesn't always happen too. And then you have the perfect storm. You have a checked out association counsel, or one who's consumed the Kool-Aid and just does whatever the association says, or the management company.
Yeah.
Sometimes the management company is, controlling the association counsel, which is a huge problem in and of itself. But, if you have a management company that's doing a horrific job, and an association that's just allowing this to take place, at some point, as a safety net, hopefully the association counsel steps in and counsels the association. Says, hey, we really have a problem with the management company. Here are the problems that it's causing. We need to take action, and here's the outlined breakdown of the action that we could take.
It almost seems like that a good association should always have the checks and balances.
Correct.
It seems
and they
like,
should.
Yeah.
The management company, well functioning, comes in and sort of helps navigate the world of association, or the world of association management, right?
Yeah.
Collecting dues, maintaining common area, working with vendors.
Yeah.
And then on the other side, you have the attorney, the association attorney, who hopefully is making sure that we're operating within the CC&Rs, that the board is complying with its fiduciary obligations, et cetera.
Yeah.
I don't see that here because no one calls me and says, hey, my board's functioning well.
This very much feels like the three branches of government, if you will. If you think if you think about it, the executive branch being the board, the board, or if you will.
Yeah,
it's really interesting
when it's functioning.
When it's functioning. Yeah. When I think of negligence, and I think this is a perfect segue. When I think of HOA negligence, the one case that always comes to mind is the Surfside Champlain condo failure of, I think, was it 2 years ago?
Yeah.
2 years ago at this point, where, everyone remembers it was a huge national story where, the tower in, I forgot how tall the tower was, but it was in the realm of 10 plus stories.
Yeah.
And the tower collapses and 93 people are die in the middle of the night. You come to find out, and it's really hard to reconcile that. Like, we live in a first world country that has these these
codes, regulations.
We are regulated to the nth degree. How does something like this happen? And then the onion starts getting peeled back, and you realize that there's failures all the way through it, but a lot of it had to do with negligence. I think the overall overarching thing was that it was negligence on many fronts, but a good portion of that is the board and deferring and not getting proper inspections, or worse, you're getting the inspections. They say you need to do something about this, and they keep putting it off, not doing anything, and then a small problem becomes a big problem, becomes a literal disaster.
Yeah. I mean, it was a disaster and it was absolutely devastating.
Yeah.
And I think what is maybe most devastating is that it absolutely could have been avoided.
Yeah.
And, obviously we analyze things. I'm a California lawyer. This is a Florida situation. But
we should clarify too. We do. We do have an office in Florida.
No, absolutely.
Yeah.
Jeff has been on the show. He's the managing partner of our Florida office. He's opined about the devastating situation that happened with Surfside. And ultimately, where it lands, and I think most people looking at it, not only lawyers, but it could have been avoided had the appropriate measures been in place.
Yeah.
Or been followed. I should say been followed.
Yeah.
Because when we look at negligence, we're always looking at the standard of care.
Yeah.
And, from what I understand is there were certain warnings or situations that were happening that were just ignored.
Yes.
By a board. And the board just ignored, deferred. And it created a perfect storm and a perfect situation where something like this could happen.
Yeah.
It should have never happened in the first place.
100%.
Now, I often applaud Florida because Florida has taken very assertive action to hopefully make sure that nothing like this ever happens again.
Yeah, we did the most recent episode with Jeff where we talk about all of the 2024 laws, HOA laws that came into effect. Jeff went over a good chunk of those, and really the amount of laws that Florida's response to such a disaster was actually it was pretty amazing, actually, that they came in and they really put in some strong legislation to ensure that something like this can't happen again. And the penalties of such are significant, to say the least.
Yeah, well, I think what people realize is when you have a board, that board is in such a position of power.
Yeah.
And, often when a board is acting poorly or failing to perform, there's certain consequences, and typically those are economic.
Yeah.
But what I think people are waking up to is like, no, life and safety is at risk as well. Life and limb.
Yeah.
The board is charged with not only sort of an economic responsibility, right?
Yeah.
They want to preserve fair market value of the community.
Yeah.
But no, this goes so far to say that they're responsible for the safety of individuals. I mean, building codes, enforcement issues, CC&Rs, all of this exists for a reason. And of course it is to preserve fair market value, but it's also to preserve safety.
Yeah, I mean, we have things in associations. Just in a standard single-family home association, things like pools,
right?
That have an inherent danger to them, like
Correct.
most things in this world. But still, there is an element of danger that you treat it with some sort of respect, and to the extent
Correct.
that it isn't, bad things can happen.
Absolutely.
Same thing with condos, that multi-story condos, or even just condos that share walls. I mean, things can happen there that, if they're neglected, can have real severe and lifelong damages that can be incurred by them. I think that's a good segue of, let's go over maybe a couple more examples. I mean, we talked about Champlain and the towers, but a couple of good examples of negligence within the community that people can resonate with.
Yeah, I'll start with sort of the usual suspects, if you will.
Yeah.
So if you go to a condo, I think condo is one of the easiest to look at. Roofing. Roofing becomes very problematic. And often what it is, it's the same fact pattern, is you had a roof that falls into a state of disrepair. The board is notified of the situation over and over and over again, and the board does nothing to respond. They take no action.
Yeah.
They ignore it. And then subsequent to that, a big rain event occurs and condos get flooded.
Yeah.
Okay, there's your damage. They didn't take action even though they were notified they should, and that falls below the standard of care. So roofing is a big one.
You've seen, I'm sure, hundreds of cases over the years on various topics. When it comes to negligence, what is the excuse? What excuse do you possibly see? It's not their money. That, you know what I mean? It's not their. So it feels like there's no excuse. Is it just lack of time? They have to yield some sort of an excuse every once in a while. Oh, I didn't get the email.
Sometimes it's that. Sometimes they say they relied upon an expert. They relied upon someone's recommendation. And, if it really gets to a point where we're in litigation and we're forcing the issue, often, I've seen situations where they've absolutely fabricated They relied on nothing. There was no reliance on anything. They just didn't do it.
Wow.
And so when you see something like that, a dilapidated roof, a lot of it is just incompetence, lazy, or they don't take it seriously.
Right.
Because it takes effort. It takes thought. It takes, sort of being a responsible board member to actually put things into action.
Yeah.
And, when we see things go south, it's often just because they didn't do it. They didn't care to do it. They didn't understand the need to do it, maybe.
Just put, or just, we'll put it off.
We'll defer. We'll do it later.
Oh, we have to have a special assessment. We're going to have this. So maybe the dominoes that fall are just like, oh God, let's
deal with
wait
it later.
on this.
Yeah,
Deal with it
let's
later.
just do the fun stuff and let's think about this later. It's not impacting me as a board member.
Yeah.
I live somewhere else. I'm not under the roof that's impacted. I'm on the other side of the building. I'm dry. And so it could be that.
I've got so much to do with my kids' little league and this bit job that I'm dealing with. We'll work on this later.
So we see that. The other area that I see is piping. A lot of negligence when it comes to piping. And often what it is there's a known leak of some sort that's just never remedied or properly looked at. And, sometimes what happens is you have a really serious plumbing issue.
Yeah.
And they send the wrong person.
Yeah.
Someone who does the cleanup in the community, who does the handyman to do a very serious plumbing task.
Yeah.
And they fail to do so. And so maybe it's cutting corners. Maybe it's not just putting the intellectual rigor that it would require to do it right, which I would say is just...
they just went lowest bid and it was...
Or just lazy.
Yeah.
Hey, this person works here. Let's just send him or her to go do it.
Even
though... No, this was a massive repiping situation where you needed someone with a tremendous amount of experience and competent. They need to be competent in the area.
Yeah.
But it was easier just to send this other individual.
Sure.
And because of it, the pipes break and, condos get flooded.
Okay. 2 scenarios for you. Okay. Let's just say, we live in Southern California. There's a lot of older homes around here built in the 60s and 70s. Things like lead paint and asbestos is, that's a common area.
Right.
And leave it alone, it's fine. You disturb it, you have a problem.
Right.
Let's go 2 scenarios. Number 1, there's an issue in the home, or it could be a common area, it could be within a condo's walls, and they know that there's asbestos. They don't tell the contractor about this, so that could be negligence number 1. But on the flip side, they know that it's one way, and they have it done, and now it's exposed to the homeowners, and so it does get back to the homeowners themselves. So I know I know what you're gonna say. Well, contractors, that's a totally different dispute.
Listen, if they're omitting information to an expert, that becomes problematic.
Oh, sure.
If they knowingly didn't disclose, that becomes a whole different issue. Now we're in sort of breach of fiduciary. That becomes a huge issue.
Because it could be like, this is so overblown. We're not going to care about this. But then you have the ducting redone on a house or whatever, and now you've exposed 30 units that all use that same ducting or whatever the case is with asbestos.
That could be a massive personal injury case as well.
Sure.
And then, interesting in that scenario, though, if you really had a true expert come out, a true expert's not going to rely upon, a board member. Just if the board member says, hey, this is safe, don't even worry about it, take no precautions.
Again,
the expert.
That's true. But in the case of the self-dealer, or embezzler, they had family member Joe Schmo that is in for a $50,000 payday.
Oh, okay, you're right. Yeah, so now that stacks the deck a little bit differently.
Yeah, exactly.
But yes, if you're looking at that, that is intentional. That's not that's intentionally falling below the standard of care, I suppose. Self-dealing, you're making money on the side. Again, that becomes very problematic for the board member.
And not to digress, but I would assume that we go over so many cases, and we've done so many different dispute types and so many different. A lot of these just are bled together in terms of it's not just one thing or another.
Correct.
It's usually there's a link where there's a negligence here and because of failure to repair. Like there's a lot of things that are all tied together.
Typically, it's more than one cause of action.
Sure.
Where you have negligence, you might have breach of fiduciary.
Yeah.
And where you have breach of fiduciary and negligence, you might have breach of CC&Rs.
Yeah.
So it becomes a bit of a laundry list of causes of action that end up being asserted against the association.
Interesting. Okay, so let's assume that you make a claim. You're a homeowner that says there's some negligence going on around here. Is there always going to be damages? In most cases, when there's negligence, is there going to be damages?
I wouldn't say there's always damages. Let's take a pipe leak.
Okay.
You have a leaky pipe. It's kind of dribbling a little bit into the unit.
Yeah.
Maybe it's like a $5 patch. And you go to the board and you say, hey, this is problematic. We have the leaking pipe. This is going to become problematic eventually.
Yeah.
And they come in, they fix it. Okay, I think problem solved maybe at that point.
Yeah.
And their damages at best are de minimis, virtually nothing.
Yeah.
The issue, or often where the lawyer steps in, is where the board knew about the leaking pipe. It continued to leak year after year. Board does nothing. And by the way, the homeowner can't do anything because it's a common area pipe.
Sure.
So even if the homeowner was a plumber who understood how to fix a pipe, they would not be permitted to do so. They're barred.
Yeah.
The only recourse is to go to the association, notify them, and sometimes they do it through the management company, and then the management company notifies the association. But that is where you get real negligence, because over several years, that water damage becomes serious.
Yeah.
It could be structural, it could be mold, it could be a hybrid of both.
Yep.
So, yeah, I'm sorry. A little bit different, though. You said, can you have negligence without damages?
Yeah.
And I think from a legal perspective, you need to have damages to actually round out the elements of negligence.
So let's use the Champlain Towers.
I think you could use they fell below the standard of care.
Okay.
Right. I think that's a better way to articulate it.
Yeah.
But damages have not been realized.
Yeah.
Because there's been no injury yet.
Right. But okay, so in the case of the Champlain Towers, it wasn't damaging. There was some structural damage that was continuing to happen, and that water from the pool seepage was coming in there, and it's starting to eat this away. But there's no real damages to any of the homeowners yet.
Well, no, I wouldn't say that. And again, I have to look at it from a California perspective.
Sure.
But if you take the tower before the collapse, and you were to analyze it and have an expert come out, and the expert would say, well, this thing is problematic structurally, it's failing. The units, the fair market value probably suffered significantly.
That's a very good point, actually.
Because if you had to disclose that, no one's paying full fair market value.
Yeah.
In fact, probably people would pay maybe 10% of fair market value.
Sure.
You're taking a 90% haircut because of the structural issues.
That's a very fair.
So you would have
argument.
damages.
Yeah.
You would.
Okay.
And real damages.
Yeah. Okay, so let's walk through. I'm a homeowner. I have some sort of negligence claim. Let's go through our. One day we're gonna do an acronym. We will.
Yeah,
do an
I was thinking about
that
that before the show. What it could be. I came up with nothing, but
it's because you didn't run it through. We'll next episode we'll run it through AI and see what it comes up with.
AI will come up with some wonderful acronyms for us. All right, so yeah, what do we do? Always document it. We always go over that. Photographs. Experts, anything you can do to create something you can refer back to.
Yeah.
That's always helpful. Visuals, emails, whatever.
You got a video camera in your pocket now.
Wonderful. Yeah. And you can take photos, you can send email. Actually use your iPhone.
Yeah.
Or if you're an Android user, use that. But yeah, document. And then of course, always review the governing documents.
Sure.
If you don't have them, request them. You should have them. Every homeowner should have them, and figure out exactly where the obligations of the board arise from. And it's typically in a provision.
Yeah.
And if you go to the index, they tend to be user-friendly. Even the older CC&Rs, written on typewriters, you can still navigate them pretty easily. So review the governing documents.
Okay.
Then, reporting the problem. This is sort of the informal play before you even ratchet it up to IDR. So running this through, you document it. You understand what provision you think the association has violated. And then at some point, you got to notify the board. You got to put them on notice. I have a leaking pipe.
Yeah.
And here's the photos. And based upon my read of the CC&Rs, the association is responsible for common area pipes. So maybe we could work this out.
Yeah.
And again, I recommend you do that in writing.
Yeah.
But that's sort of the first attempt to resolve it.
Yeah. And then going back to the previous episodes, elevate your vocabulary. If you're using legal terms and you have an elevated vocabulary, they're more likely to take you seriously because you've done some due diligence.
I would say so.
The perception is that you've done more due diligence, and and you should be taken seriously.
Correct. You're informed. You understand your rights as a homeowner.
Yeah.
And I always say this, but the less emotional you can be, the better.
Yeah.
If you can come across clinical, matter of fact, this is a problem.
Yeah.
CC&R say that you need to help. Please help.
Yeah.
Okay, that's better than, you guys are a bunch of idiots, and
which might be true.
Which might be true. Not to say that that's not a true statement, but it's not a helpful way to position it.
Yeah.
Because if they don't respond to you, you don't need to use the theatrics, because you'll have remedies in other areas.
Yeah.
And I guess I say that too because eventually this gets before, if it does go this far, it gets in front of a mediator or it gets in front of a judge and jury.
Yeah.
And if there's a bunch of emails where you're just putting the association on blast, that might impact the way they see you, rightfully or wrongfully. And my perspective is I empathize tremendously with homeowners because they are living through hell.
Yeah.
It's a nightmare. I get that. I mean, from a very visceral, emotional level, I understand how frustrating it is.
Yeah.
But at the end of the day, you don't want to paint yourself out to be that way. The more clinical, the more matter of fact, the better.
Yeah.
So put them on notice. And then if you're not getting any traction, they don't respond to your email, they don't send anyone out, then elevate to informal dispute resolution if you're in California.
Yeah.
I'll qualify California because I don't know other states.
Yeah.
But under the Davis-Sterling Act, you send an email to management company or the board or both, outlining the dispute and saying, at this point, I'd like to engage in informal dispute resolution under the Davis-Sterling Act. Please let me know some days and times that we can meet.
Yeah.
It's it's rather simple, but going to your point of elevation and coming across a little bit more sophisticated and educated, IDR tends to be a good way to angle it.
And they have somewhat of an obligation to respond, as where it says in the Davis-Sterling Act, they still might not.
General consensus is it's a good faith. That's the spirit of the Davis-Sterling Act. The parties are operating in good faith.
Right.
You want to come to the table, both sides, in a very practical way and non-contentious, which, by the way, doesn't always happen. If it did, we wouldn't get so many phone calls. But, in theory, yes, they should respond to that.
Yeah.
But they don't always.
Yeah.
And then if they don't, and they ignore that, the IDR, then you start contemplating whether or not you bring on a lawyer.
Sure.
Or at least have an advocate, meaning lawyer, look at the dispute and advise you accordingly.
Yeah.
That's the play.
And we've mentioned this before too. If there is damages that are incurred to you personally, perhaps have a professional come out and assess that and determine what the causation is and what it would take in terms of like financial, what's going to take in terms of dollars and to get you whole again.
Correct. How do you reinstate? How do you bring it back to where it was before the damage?
Yeah.
And, I often think that when you're meeting with a lawyer, if you do have some sort of expert report, it can be very helpful to the attorney. Because, listen, I'm not a roofer. I'm not a plumber. I don't necessarily know how to analyze from a, professional tradesperson perspective what is happening.
Sure.
But if I can look at a report and they say, what we've observed, it looks like A, B, C, D, and E, and to repair, it's going to cost this. Okay, now I have something to work with.
Yeah.
And that's not to say that that's going to be the definitive report in the dispute, but at least gives me some bearing, and I can start to triangulate based upon that.
Right.
And I think any good lawyer, it would be helpful for that lawyer to have that information.
Interesting. Well, time for your favorite part.
All right, the rapid fire.
Yep, we've got a So every episode we go through and find on the subreddit FHOA You know what the F stands for. And we find a case or a post there that has to do with the episode.
Okay.
So I'll go ahead. I'll read you the post, and you can give us your 2 cents. The title: HOA neglected mowing for 6 months. Now I'm fined for doing it myself. Hey everyone, I'm in need of some legal advice because my HOA has officially lost it. We have a small common area at the end of our street that the HOA is supposed to maintain. Well, 6 months ago, they just stopped mowing it. The grass grew to waist height, weeds everywhere. It looked like a jungle. I emailed, called, and even ran into the HOA president in person, but got nothing but excuses. So after 6 months of this, I took matters into my own hands and mowed it myself. Felt good, problem solved, right? Wrong. A week later, I got a letter from the HOA fining me for $250 for, quote, unauthorized landscaping, end quote. I explained their negligence, but of course got no response. Now they've upped it to $500 because I haven't paid. And the kicker, they just announced a new lawn service starting next month like nothing ever happened. Do I have any legal standing here to fight this fine? Can they even enforce it after neglecting the area for half of a year? Any help is appreciated.
This is an interesting one. All right. Again, I'll assume it's California.
And there's like a lot of different through lines, and call it negligence, there's a lot of different.
So you might have various causes of action.
Yeah.
So let me start with an assumption. I mean, if it's a common area, likely the obligation to landscape is on the association. Yeah. By way of the CC&Rs. So there would have been a provision that says that the association must maintain the landscaping or landscape the common area.
Sure.
Mowing the grass would fall under that, right?
Yeah.
So to not mow it for 6 months or not attend to it for 6 months, you're probably in the negligent category, right? It fell below the standard of care because if I got a landscaper out, I would imagine a landscape expert would say that you should probably mow your grass more than once a year. Right? And why is the common area important? Well, now we're looking at preserving fair market value to the community. So it actually has a utility. Yeah. It looks nice, but let's say you're going to sell your home and a new buyer looks at this this jungle that might not go over so well. Right? Mm-hmm. So that might actually hurt the value or the value of the homes. So what happened here, though, is instead of the homeowner sort of enforcing, right, because they could have come at the association maybe on a breach of contract theory, a negligence theory, possible breach of fiduciary theory, they switched into self-help mode, which typically isn't advisable, right? Because now, as opposed to coming in with the upper hand, they technically did something that they're not permitted to do. So just because your association is violating the CC&Rs doesn't then authorize you to go breach the CC&Rs yourself.
Sure.
It's similar to that common area pipe that I was discussing. You don't have the right to fix anything common area.
Yeah.
Now, there's some sort of arguments around what if it's an emergency? What if it's flooding? Fine. Putting those extraordinary circumstances aside, to go and mow, that was not permitted. It wasn't authorized. You didn't have the right to landscape the common area.
Yeah.
In fact, you're angling on this, your recourse would have been much different.
Yeah.
So what do you do? Well, I suppose first and foremost, you probably want to pay the fine. What would be an interesting strategy, though, and this is thinking a little bit outside of the box, is you pay the $500 under protest, right?
Okay.
So you pay it because you don't want them to leverage that fine against you in some other way. You pay it under protest and maybe file suit in small claims to get it back, to disgorge the $500 and put it in front of the small claims bench. Typically small claims are pretty user friendly. It's under the $12,500 jurisdictional limit, so you could go after the $500 and see what a small claims judge does with it. And you would argue that you resorted to self-help. I don't know if you win that though, but you could always roll the dice and see what happens. But that could be a strategy. Now, the fact that they've now hired a landscaper, great. It looks like they finally did get their act together. How do you go after them for the 6 months that they didn't maintain the common area? I don't know. My trouble here would be damages. How can
Right.
we put a definitive number on what happened? And I think most attorneys would kind of hit a wall at that point. Now, if you were 2 or 3 months into the dispute, you could have brought in a lawyer at that point, send a demand letter,
Sure.
start, putting fire on their feet to make them move on this. That didn't happen. You sort of waited the 6 months, resorted to self-help. Now they sort of have you in in the crosshairs. So it's less than ideal.
My assumption, and I've lived in an association, guilty on this front, is I think a lot of homeowners just don't know their CC&Rs.
Right.
They don't know what's in there. They frankly don't care in most situations. It's just like it's there. I'm just living my life. I've got I got to put food on the table. I've got
Right.
kids running around. This is last thing. But when something like this arises, going back to almost every episode we've ever talked about, document it first and then go to your CC&Rs, because again, the big misconception that I was like completely in this camp was the CC&Rs tell you as a homeowner what you're allowed and not allowed to do.
Right.
Which and this is me. I've lived in an association and never realized it until we actually started talking about it on this show. Was no, it's not just for the homeowners. It also outlines the obligations of the association themselves.
Correct.
So knowing that, what would have been a big win for this particular person was go to the CC&Rs, find where it says they are obligated to maintain the common areas, and then use that as they could have gone back, then put an email, documented it, showed in the CC&R where they were violating it, and then you would have had probably a much better outcome.
I think you would have had a greater impact. IDR would have been appropriate here too if they ignored the first letter. So I think if they were proactive earlier on, they didn't wait the 6 months, really enforce it. And listen, I know why they went and cut it, because it drove them crazy. I'm not, from a human perspective, I get why they did what they did. It just wasn't ideal given the legal framework that they operate in.
Yeah.
So I get it.
Making a wrong make two wrongs don't make the right.
Correct. And so I think they would have had some really good sort of firepower initially.
Yeah.
But they sort of flipped it a little bit. They lost some leverage on it. But, they could always run the small claims play and see what a judge does.
Run the small claims play, just so I can get. I just want to hear, but I want to hear the comment back. Say this is what it ultimately resulted in.
They could write back and say, "No, I lost." Because you never know what's going to happen in small claims.
Well,
it's always a gamble.
Do what you must, but if you end up doing it, I'd love to get a comment, just knowing what it would.
But at the end of the day, we're not giving legal advice either.
Of course,
I'll qualify that.
Yeah.
So if anything, we're mapping out some hypothetical options, but talk to a lawyer, confirm with a lawyer, and then go from there. I do it that way.
Asterisk. Make sure this is not legal
my
advice.
Nature.
Yeah, I know. Good for you. Okay, that was a fun one. The next one we're going to talk about for next week's episode is solar disputes in HOA, and you can talk about that for a second. But I think this is a broader topic, realistically, on where it's going to open up with so many CC&Rs these days were written for communities 90s and even earlier, where solar was not even a consideration.
Well, the technology wasn't there.
Or even like drought tolerant plants and things along those lines, where the laws have changed.
Right.
So I think it gets into a broader topic, but I'm interested in your take as well.
Yeah, well, solar
tease that a little bit.
Solar has been a hotbed. I don't know if that's a pun. It's not really a pun, but still with the sun. But solar disputes, especially in the context of an HOA, has really been at issue recently. We've seen a rise in those disputes because there's tension between state, right? What California wants to do with solar, encouraging solar.
Yeah.
And archaic or antiquated CC&Rs. And so where the tension lies is, homeowners, seeking to do something good, go out, install these solar panels, and the association takes issue with it on some level. And so really, how do you strike that balance? Where are the homeowners' rights and what are the rights of the association?
Sure.
In terms of regulating the community.
Yeah.
So
that's going to be a fun one.
Yeah, that's next time, thanks for watching, and like and subscribe. Is that how you say it?
Something like that.
Yeah, and buy some merch. We don't have merch.
We don't have merch.
All right. Thank you, guys.
But we might after this episode.
Yeah.